There are certain landlords that are exempt from FAIR Ordinances in the city of Portland. Those landlords are individuals that have a unit that is affordable housing for those at 80% median family income or below and are subject to Multnomah County's Coordinated Access System. Landlords with formal agreements with nonprofit service providers or government housing providers, a unit that is not advertised to the general public. If a landlord and tenant are living in the same dwelling or living next door to one another in a duplex, or if the tenant lives on the landlord's primary residence property in an ADU. For all other landlords that own a unit in the city limits of Portland, the Fair Housing Ordinances apply. If you are unsure if your unit is in the city of Portland, you can go to portlandmaps.com to find out more. The Fair Ordinance covers quite a few different topics. In this video, we will be speaking about screening criteria, expectations, and the denial process. When it comes to screening expectations, there is a standardized basic screen, and then there is an opportunity to either do what is called a low barrier screen or a landlord choice screen. First, let's look at the basic screening minimums. These are specific to identification as well as income. When it comes to identification, a landlord can no longer ask any questions pertaining to citizenship. An applicant cannot be denied for not having a social security card or number. However, the landlord can still ask the potential tenant to provide documentation that would verify their date of birth, name, and photo identification. This could be one of the following, or a combination of documents. When looking at somebody's income, the Portland Ordinance now defines who is an applicant versus a non-applicant. Applicants are individuals who will be tenants in the household as well as liable for the rent moving forward. Non-applicants are household members that will not be responsible for rent payments in the future. Non-applicants can still be screened regarding their identification, their criminal history, and rental history. If accepted, they may be asked to sign a rule of residency agreement. Another part of the income screening criteria is that all forms of income must be included in reviewing the applicant. This means that if somebody is receiving assistance such as food stamps or utility assistance, the landlord has to take in consideration those additional sources of income. Lastly, landlords can now only expect potential tenants to be making 2 to 2.5 times monthly income to rent, depending on the amount of rent. The Portland Housing Bureau publishes documentation every year about what rent should be for those at 80% median family income. Those are based on the size of the units available in the city of Portland. If a landlord is going to charge less than the amount shown as the affordable rent amount for the size of the unit, then a landlord can only ask that a potential applicant has 2.5 times the monthly rent to income ratio. Whereas if the rent is more than what is affordable for that size of the unit, the landlord can only ask that the individual be making 2 times the monthly income to rent ratio. If a tenant does not meet the income requirements, a landlord can still move forward with renting to them by having 2 separate options. One being that they pay an additional security deposit, and the other being that they have a guarantor. If they are going to opt for an additional security deposit, then they need to inform the applicant in writing. If the landlord is asking for a guarantor, that time frame still applies, but the landlord cannot ask the guarantor to have more than 3 times the income to rent ratio. Both the identification piece and income piece are the bare minimums for screening somebody in the city of Portland. Beyond that, if a landlord wants to do a deeper dive into the person's background and history, they need to have pre-selected whether they are going to choose to do a low barrier screen or a landlord choice screen. First, we'll review the low barrier screen. The low barrier screen has certain qualifications for what a landlord can and cannot review. When speaking about somebody's credit history, landlords can no longer take into factor scores that are above 500. A landlord cannot set the bar higher than 500. A landlord should also not be taking into consideration insufficient or lack of credit history, unless the tenant is lying about this. Any prior property debt of $500 or less should not be taken into consideration, as well as any other debts that are less than $1,000. If there has ever been a bankruptcy in the applicant's history, and it has been discharged or is in an active repayment plan, it also cannot be taken into consideration. And lastly, landlords are no longer able to deny somebody based on medical or educational related debts. In regards to rental history, in a low barrier screen, landlords cannot factor in insufficient or a lack of rental history unless the tenant is specifically lying about this. They are still allowed to reach out to other landlords and previous rental reference in regards to how this tenant rented in the past. But the only specific information that they can base any judgments on are if there have been defaults in rent in the past, if there were 3 or more documented lease violations in the last year, if there is an outstanding balance due to a landlord, and if there have been any lease violations that would have resulted in a for-cause eviction. Rental history also includes eviction history all across Oregon. Any evictions that are on somebody's record that are 5 years or older are not allowed to be taken into consideration. Portland has put in new specific guidelines for those living in the city around which past evictions can result in a denial notice. If an eviction was dismissed or the tenant won, regardless if it happened today or in the last 5 years, it cannot be considered. If an eviction was set aside or sealed by the court, it also cannot be considered. Any eviction that is 3 years or older that was in the landlord's favor can also not be considered. This then takes our window down to the last 3 years. But even in the last 3 years, there are supports for tenants. If an eviction was in the landlord's favor, but it was a no-cause notice, or it was related to a failure to appear by the tenant can show credible documentation that they were out by the stated time on the notice, then it cannot be considered against the tenant. And lastly, when reviewing somebody's criminal history, a landlord cannot factor in arrests that led to a conviction, judgments that have been or are currently being dismissed, expunged, voided, or invalidated for any reason, convictions of a crime that are no longer legal in the state of Oregon, convictions or judgments through a juvenile justice center, misdemeanors in which the sentencing date is older than 3 years, and any felonies in which the sentencing date is over 7 years old. If a landlord is going to choose a low barrier screening criteria, and after reviewing the screen, they intend to accept, they will be entering into a lease agreement with that applicant. If they choose to deny, and it is pertaining to criminal history, then the landlord needs to take into consideration any supplemental evidence that the applicant has provided. If that supplemental evidence would overturn the denial, they would enter into the lease agreement. If it would not overturn the denial, then written documentation of the reasoning behind moving forward with the notice of denial, as well as why the supplemental material did not work, is provided to the tenant. It is highly recommended that applicants choose to submit supplemental evidence with their application at the time of applying to help resolve any future denials that may come up. Applicants are welcome to attach personal letters, reference letters, income and identification documentation, reasonable accommodation letters, as well as rent well certificates. Now we'll be looking at the landlord choice screening. Beyond the basic screening, In regards to identification and income, landlords using a landlord choice screening tool can choose to set their own criteria. The outcomes of these screenings could be approve, a conditional approval with a guarantor, or an increased security deposit, or the intent to deny. If the landlord intends to deny somebody before the notice of denial goes out, they must account for the individualized assessment of the applicant. They need to consider the nature and severity of the incidences that have led to this possible denial, the number and type of incidences, the time that has lapsed from the date of the incidences, and the age of the person when these incidences occurred. If through the landlord choice option, they intend to accept somebody, they would move forward with entering into the lease agreement. However, after screening somebody and their intent is to deny them, they must conduct an individualized assessment and consider all supplemental evidence at hand. If the supplemental evidence would overturn their intent to deny, they would be entering into the rental agreement with this applicant. However, if the supplemental evidence would still lead to a denial, then they need to provide the tenant with a written notice of denial, along with explanations of the reasons why the supplemental evidence did not negate the screening results. If an applicant receives this notice of denial, the written notice of denial needs to be returned to the applicant within 2 weeks of determination. The applicant is then allowed to have 30 days in which to appeal the denial. This appeal process is an opportunity for the applicant to provide additional materials and information to hopefully overturn the denial. If the appeal has been approved, then the newly pre-qualified applicant has the opportunity to lease up with the landlord for up to 3 months from the date of the overturned denial. The landlord can ask the applicant to self-certify, stating that nothing has changed in their background in those last 3 months. If a landlord fails to comply with the FAIR Ordinances, they are liable for up to $250 per violation, plus actual damages, as well as reasonable attorney fees and costs. For more information, go to the Rental Services Office Help Desk